What's up, your backup plan tribe, to another awesome show of Walking with Tina, celebrity family estate feuds, and estate topics. And of course, this week's topic is what happens to your bank accounts after death. What do you think? Comment down below if you know. It's sometimes a mess. So we're going to talk about it today. And that's what we talk about today. I'm Tina over here. If you don't know me, my name is Tina again. I am the creator and developer of your backup plan app. I'm a best-selling author of In the Blink of an Eye. Just like that. Whoosh. Your life changes in a second, in a flash. Yeah, and that's what we talk about on our podcasts each and every week. So make sure you like, share, and subscribe down here to our channel so that you get notified when our new shows come up. Our lives are on our podcasts as well, on all podcast platforms. And our YouTube channel is our lives and our Walking with Tina. So I'm so happy to have you guys here. Make sure you smash that like button for your girl. And I'm so happy to have you guys here. I am a financial advisor and emergency preparedness coach. And of course, there's nothing more to prepare everybody to coach them in how and why you should put your stuff together. And it's stories that we learn a lot more about why you should do it and what's hidden behind the scenes. And a lot of times we're just not explained the reasons why until something bad happens when you're actually having to deal with someone's estate. And so that's why you have me here to help you put these types of financial documents together, medical information, perhaps financial documents that could be in your closet or in your drawer in the kitchen or in the basement, and all of these different places, and nobody knows where your wills are or your power of attorneys or why you should have one, or you just don't understand why. So we're going to take a quick minute and have a quick commercial break. I'm so happy to have you guys here, and I'll see you back in a second.
Wow. It's here. Finally, your backup plan app. To put your life in one place in preparation of any unpredictable circumstance. Grab it today over on iTunes and Google Play and get your backup plan started. Whether it's organizing your estate plan, your exit plan in a storm, your emergency plan in the blink of an eye moment. It is the best gift you can have at your fingertips for yourself and your loved ones.
Welcome back. Welcome back. I'm so happy to have you here. What happens to your bank accounts after death? Let's see. Well, unless you've actually worked at a bank, you probably don't know the answers, because it always seems to be more complicated than it needs to be. Isn't that the truth? Details after death, the complications family will have with their person's bank accounts. Oh, I can't tell you how many clients have come to me after the fact and have said, I wish I would have looked into this beforehand, Tina. I wish I would have gone over this with my parents. I wish. So let's not have any regrets now, because we are going to know why. And we do workshops of these on our Facebook group right here, linked down below. It's also in the description box. If you want to get into a webinar, a free webinar that we have in our Facebook group, you're welcome to join. And we have so much information in there. We talk about family conversations. We have appies and sometimes alcohol or coffee and tea, and sit down with 6 to 8, 10 people of the family and really go through the worksheets and laugh and joke. And it's just really a fun time. So that being said, after a person's death, their bank accounts and their investment accounts can present a range of complications for their family and the estate. In many cases, the process of assessing and distributing these assets can be very time consuming. Yeah, that's for sure. Confusing and emotionally difficult because you're dealing with all the pressures of losing the person, and on top of that, the complications and the issues that you have in front of you. It's just so overwhelming. Below, of course, I'm going to give you some of the common issues that families may encounter when with a deceased person's bank and investment accounts. The first one is assessing the accounts. The first and most fundamental issue that families may face in gaining access to the deceased person's account. In most cases, banks and investment companies require a death certificate and other legal documentation before they will release any information or even allow access to the account. This process can be lengthy and very frustrating, that's for sure, especially if the family is in urgent need of the funds. And a lot of times, I had clients who weren't on the bank accounts as another person on the account. And so it was after the fact, going in and trying to find out where the dad had bank accounts. Of course, they would have the death certificate, but they had to show proof of who they were and probably a copy of the will, either original or a notarized copy. And it always causes so much delay. It causes problems when you want to get the funeral dealt with, and you don't necessarily, the family doesn't have the money to do that without these funds that are in the bank account. So it causes a lot of delays and circumstances that you don't need to really deal with if you only dealt with it beforehand. Once the family has gained access to the bank accounts, they may be faced with the challenge of understanding the account types, the balances, and other important details. This is especially true if the deceased person had multiple accounts or investments, or if the accounts were held with other different financial institutions. The family may need to consult with family advisors or other professionals to help them understand the nature of the assets and how they can be distributed. Before any assets can be distributed to the heirs or the beneficiaries, any outstanding debts or expenses of the deceased person may be resolved. This may include funeral expenses, medical bills, outstanding loans, and other obligations. The family may need to work with creditors, credit card companies, and financial institutions to ensure that all the debts are paid up and any liens or any encumbrances on the accounts are then cleared. In many cases, the deceased person may have named beneficiaries for their bank and investment accounts. However, it is also possible that the accounts are part of the person's overall estate and then will be distributed according to their will and, of course, provincial and estate laws. The family may need to work with attorneys or other experts to identify the beneficiaries and ensure that the assets are distributed correctly. In some cases, there may be disputes over the ownership or distribution of the deceased person's bank and investment accounts. This can be especially true if the person did not have a clear and comprehensive estate plan in place. Disputes may arise between family members, always beneficiaries, or other interested parties that come out of the woodwork and may require legal intervention to resolve it. And this, of course, causes extra money to come out of the estate because you're fighting it. It's going to prolong it with time, and it's the drama and the undue problems that come from all of that. Finally, the family may have or need to deal with tax implications related to the deceased person's bank and investment accounts. Depending on the nature of the accounts and the amount of assets involved, there may be estate taxes, income tax, or other tax liabilities that need to be addressed. The family may need to work with accountants or other tax professionals to ensure that all the taxes are paid correctly and in a timely manner. Overall, dealing with a deceased person's bank and investment accounts can be very complex and challenging process. Yes, it is. It is important for families to be patient, thorough, and proactive in their efforts to gain access to the accounts, understand the accounts involved, the assets involved, and ensure that they are distributed correctly and according to the wishes of the deceased person. Seeking the guidance of legal, financial, and tax experts can be very instrumental in navigating these challenges and achieving a successful outcome. When someone passes away, various types of bank accounts may need to be resolved as part of the estate settlement process. The specific types of accounts can vary based on the jurisdiction and the individual's financial arrangements. However, here are some types and common types of bank accounts that are typically involved in this resolution process. This you may find very interesting because there is a whole whack of different types of accounts that you may not even be aware of. So, for example, a checking account. A checking account is used for day-to-day transactions, such as writing checks or making electronic transfers and withdrawing cash. When someone passes away, their checking account may need to be closed, and the funds may need to be transferred to the estate account or distributed to the beneficiary as per the terms of the will or, of course, the applicable laws. Savings accounts are very similar. A savings account is designed to hold funds for long-term purposes or as an emergency fund. Similar to a checking account, the savings account will need to be addressed after someone's passing. The account may be closed and the funds can be transferred to the estate account or distributed as per the legal requirements. Joint accounts are very common as well, and they are held by two or more individuals, and if one account holder passes away, the surviving account holder generally gains full access to the funds. And I have to laugh because so many of my clients have said, after having their spouse pass away, well, that's my money too. My name is on that. Isn't that always, no matter what that title of the bank account is, you still feel that way. The surviving account holder will typically need to present the necessary documents, such as a death certificate, to the bank in order to update the account ownership, and in some cases, a marriage certificate as well. So make sure you put all those documents. That's what we talk about in your backup plan app. All of these documents, we have a process of putting them all together so they're easy to access when you need them. Trust accounts. These accounts are managed by a trustee who distributes the funds to the beneficiaries according to the terms specified in the trust document. Upon the account holder's death, the trustee will typically work with the bank and the beneficiaries to settle the account. A lot of time, trust accounts can also be put in a joint account as well. They can be more than just one holder of the trust account. Now, here's an interesting one. Payable on death accounts, POD accounts. A POD account designates one or more beneficiaries who will automatically receive the funds in the account upon the account holder's death. The beneficiary will need to provide the necessary documentation to the bank to claim the funds. This type of account bypasses the probate process, making it a relatively straightforward way to transfer funds after someone passes away. it goes pretty smoothly, that type of account. Certificate of deposit, a CD account. A CD is a time-based deposit account where the account holder agrees to leave the funds deposited for a specified period in exchange for a higher interest rate. If the account holder passes away before the CD matures, the funds can be distributed as part of the estate settlement process. That's important. It's important to note that the specific procedures and requirements for resolving these accounts may vary depending on the country, your state, your province, or the financial institution involved. When someone passes away, it's advisable to consult with an attorney, an executor, or a legal professional who can guide you through the necessary steps and documentation required to settle the deceased individual's bank accounts properly. And I find that very interesting because we're not really given guidance before something happens. So that's where your backup plan comes into works, is getting all of those documents together in one safe place and then knowing what types of accounts you have. And a lot of times, some people will put a daughter or a son onto an account, and you need to know the implications are surrounding that as well. There are several options for individuals who can take before death to ensure the ease of dealing with bank accounts after they've passed away. One option is to create a joint account, as I mentioned, with a trusted family member or friend. By creating a joint account, the account becomes owned by both parties, and upon the death of one party, the other party automatically becomes the sole owner of the account. This allows for a seamless transfer of assets without the need of probate. When you don't have someone else jointly on the account, the person that has passed away and is the single individual on the account, it will have to go through the probate process. So a lot of times people will put a trusted family member or friend onto the joint account. But there's one complication surrounding that decision. And that is because it's solely owned by both individuals. If something happened to the other individual before that person passed away, such as a bad business deal or a divorce, where legal implications come into it, and divorce can be the other spouse of that person can fight for their percentage of that as well. So there needs to be a decision made when you choose this type of joint account with a trusted family member or friend, that won't happen, because there needs to be some sort of trust within the family unit to make decisions upon what's in the bank account and where is it going, and all of that type of thing. So you can imagine those implications. Another option is to create a payable on death, a POD account, or a transfer on death, a TOD account, which is designation for the bank account. This involves naming a beneficiary who will receive the account's funds upon the account holder's death. The beneficiary can be changed anytime, allowing the flexibility in your estate planning. A third option is to create a revocable living trust and transfer the bank account into the trust, which we've talked about in other shows. And we've talked about in the celebrity family estate feuds as well, when people as a celebrity create a trust but then don't put anything into it. And in this case, you would create a revocable living trust but transfer the bank account into the trust. It doesn't mean that you can't use that account as you're living. It just means that upon death, that account would be part of the trust. And then you stipulate what you want with the trust. By doing so, the account owner maintains control over the account during their lifetime, but upon their death, the trust takes over ownership of the account and distributes the assets according to the trust's provisions. This option can avoid the need for probate, as the assets in the trust pass directly to the beneficiaries. And it goes as well as celebrities transferring certain assets, perhaps even companies, LTDs or LLC companies, into a trust, and that could continually generate income even after the person's passed away for the people that get the trust. So it acts as sort of a company, kind of a company that has a trustee that looks after and administrates everything for you. It's important to note that each of these options has its advantages and disadvantages and may not be suitable for everybody. It is recommended that individuals consult with an estate planning attorney, not an attorney that deals with car accidents or other types of services, but family law and estate planning, to determine the best course of action for their specific circumstance. By taking these steps before death, individuals can ensure that their bank accounts are transferred smoothly and efficiently to their intended beneficiaries without necessary delays or complications, and sometimes without probate. Certain types of bank accounts are designed to bypass the probate process after the account holder's death. These accounts are typically structured to facilitate the easy transfer of funds to designated beneficiaries without the need of court involvement. And what's so nice about that is that it's giving the person who passes the true strength of knowing that their wishes are going to be perfectly 100% as they want them to be. Here are some common types of bank accounts that can help you avoid probate. Of course, as we talked, we have joint accounts with right survivorship. When you open a joint account with someone else and include the rights of survivorship designation, the account automatically transfers to the surviving account holder upon your death. This type of account allows for a seamless transfer of funds without going through probate. And payable on death, which POD accounts, which we talked about, also known as Taunton Trust, allows you to name one or more beneficiaries who will receive the funds upon death. The funds in the account bypass probate and go directly to the designated beneficiaries. You can typically set up a POD account for any checking, savings, or even certificate of deposit accounts, CD accounts. And then there's transfer on death, TOD accounts, which we spoke about. They're similar to POD accounts. TOD accounts enable you to name beneficiaries who will inherit the account balance upon your death. This type of account is commonly used for brokerage accounts or investment accounts, and the assets in the accounts transfer directly to the beneficiaries, bypassing probate. But always check in your location, in your estate planning attorney, with your accountant, and with your banks that you bank at to get the what's properly right for you and your situation. And then the last one is a revocable living trust. By creating a revocable living trust and transferring your assets, including bank accounts, investment accounts, into the trust, you can avoid probate. The trust becomes the legal owner of the accounts, and you can specify how the assets should be distributed upon your death. I even had some people stipulate certain ages where they can have access to those funds, or certain birthdays or certain celebrations as well. The trustee can appoint the trustee you appoint can manage the accounts and distribute the funds to the beneficiaries according to the trust's instructions, which you have laid out. It's important to note that while these accounts can help avoid probate, they still need to be properly set up and maintained. You should consult with an attorney or a financial advisor experienced in estate planning to ensure that the accounts are structured correctly and aligned with your overall estate plan. Laws and regulations may vary depending on your jurisdiction, so professional guidance can ensure that you make informed decisions in line with your specific circumstances. That's a whole lot of S's there. So I hope you've enjoyed. This is crazy how we talk. We hold these workshops, these free workshops where you can come on Zoom calls and ask questions. And our webinars are free. And we look forward to having you. The information is in the description box below for the Facebook group, as well as our Facebook page for your backup plan. And we look forward to talking about more of these types of estate feuds and estate topics. And if you have any ideas, make sure you comment down below what maybe a topic that you would like to talk about or that you would like us to do for you. So saying that, I'm excited to get on with our estate celebrity for next week, and I look forward to seeing you over there. So stay tuned, stay safe, and be kind. Till next week. Bye.